Good afternoon and welcome back to the Judicial Committee of the Privy Council. We are hearing the appeal in the case of RAV Bahamas and Therapy, and we are currently hearing the submissions of the respondent being presented by Ms. Roll QC. Ms. Roll.
I'm obliged, my Lord. Lords, prior to the break, I was taking the board through a number of authorities in an effort to demonstrate that there is indeed a requirement on the court hearing a challenge under Section 68 or indeed Section 90 of the Act to separately and independently consider and make a finding on the issue of substantial injustice. I had intended to take the board to two more, but I'm decided I'll just take the board to one more on this point and then move on to the second point. So the last case that we will consider on this point is at page 2325. It's the authority of Turner Bahrain Holding Company WLL and Bin Kamin Al Shamsi. Hope I haven't obliterated the pronunciation there. In any event, we're going to go to page 2346. And this was a challenge under Section 68(2)(a). And again, as we've seen consistently in these authorities, the relevant legal principles are being set out. At paragraph 85, first sentence, I was referred to a number of authorities, and the authorities are set out. And in the final sentence of that paragraph, you see that it says, they establish the following principles so far as relevant to the present application. 1, in order to make out a case for the court's intervention under Section 68(2)(a), the applicant must show A, breach of Section 33 of the Act, and I'll stop there, B, amounting to a serious irregularity, and C, giving rise to substantial injustice. So if we go then to page 2347, sorry, 2356, my apologies. Again, we see under the caption substantial injustice, the court then going in to the consideration of whether or not that requirement has been met in the instant case. So at paragraph 121, we see there is a further obstacle to the Bin Camille's challenge under Section 68, which is that they have not established that the course adopted by the arbitrator has caused some substantial injustice. Mr. Tackerberry QC identified various arguments which would have been addressed to the arbitrator, which he submitted might well have made a difference. I'll stop there and then go to the last sentence of that paragraph. In the absence of evidence, I would not be prepared to conclude that advancing this argument might well have made a difference. The next paragraph, first sentence, the same is true of a number of the other arguments which Mr. Tackerberry QC submitted would have been advanced. Stop there and then go to paragraph 123, very next paragraph, first sentence. Mr. Tackerberry also submitted that Turner received a benefit from the agreements so that the amount of compensation due under clause 7.2.11 was less than Turner's full contribution in HCC. I stop there and go to the final sentence on that page. There is again no proper evidential basis for concluding that this argument might have made a difference. And if we can kindly turn over to the next page, just paragraph 124 on that one sentence. Therefore, had I concluded that a serious irregularity had occurred, I would not have been persuaded that it gave rise to substantial injustice. And I stop there as it relates to that authority. And so, my lords, we say, and of course we say that this is the case with all 39 of the authorities that have been cited as between the appellants and the respondents, but certainly with the ones that have taken the board to. There is a central theme. Number one, in order for the court to be satisfied that there is a serious irregularity as envisaged by the section, there must also be the consideration of whether that serious irregularity so found has caused substantial injustice. Secondly, we see that the courts are saying that in order to make out a case for intervention, one of the authorities made reference to an obstacle, describing the substantial injustice requirement as an obstacle, and indeed stating that in order to make out a case of substantial injustice, the court of serious irregularity, sorry, and for the court's intervention, there has to be the establishment and satisfaction of the substantial injustice requirement. Additionally, a number of the authorities, specifically, I didn't take the court to this authority, but my learned friend did, the Buyak Kamlika Authority, when they talk about the ethos of the 1996 Act as it relates to the UK and the 2009 Act as it relates to the Bahamas. The whole purpose of the substantial injustice requirement is to provide protection for the arbitration award and to limit the extent and degree of intervention by the courts with the arbitral process. And so, if this protection is to have any value, if the court is to actually make a determination that they're entitled to interfere with the award, if the court is to make a determination that a serious irregularity has been established as is envisaged by the Act, how can they do that without separately and independently considering whether substantial injustice has occurred? Our respectful submission is that they have to. And this is the reason why you see it happening in all of these cases. There's no way for the court to satisfy itself that they are entitled or empowered to interfere with the arbitral process or to make a remittance order, unless they separately consider that there has been a substantial injustice in respect of each and every of the serious irregularities that they found. And we say, in answer to the first issue that arises in this appeal, there absolutely is a requirement. Oh, sorry. Yes, my lord.
I'd just like to raise a question with you, Ms. Kroll, about the way that the Act is analysed in several of these cases, and the question whether it is in fact correct. We can see my point, for example, if you wouldn't mind turning to page 2347, which is in the list of principles you were just taking us to in Turner, Bahrain.
Yes, my lord.
And it's quoted in several of the other cases, and they say things to similar effect. If you look at number 6, it says, the requirement of substantial injustice is additional to that of a serious irregularity, and the applicant must establish both.
Yes.
And indeed, that was what you were just submitting to us.
Yes.
Now, could I please ask you to look at the section 90 of the Bahamian Act, which I think we've got at 1776. It's the same in the English Act.
Yes.
And if we look at subsection 2, what it says is, serious irregularity means an irregularity of one or more of the following kinds, which the court considers has caused or will cause substantial injustice.
Yes.
Now that, as I read it, is saying that what makes an irregularity serious is, first of all, that it falls into one of these categories, and second, that it will cause substantial injustice. It is not a separate requirement to be serious and to cause injustice. The injustice is just an aspect of what makes it serious. And it's all one single test, not two elements which have both to be separately satisfied.
Well, what we would say to that, my lord, is that the manner in which the courts have interpreted that section and have in fact endeavored to comply with that section is to carry out a separate analysis. The serious irregularity, on the one hand, is an irregularity that falls within one of the paragraphs, which in and of itself does not constitute a serious irregularity as envisaged by the section. In order to be a serious irregularity as envisaged by the section, it has to cause substantial injustice. And in order to make out a case for intervention, the court then has to consider. And I think the point is made by the fact that when you see in a number of these authorities, a serious irregularity has in fact been found, and I think I'm going to take the board to a number of these in my next section. When a serious irregularity has already been found, the court doesn't stop there because the court is satisfied that they have not done what the section requires. They must then consider whether it has caused substantial injustice. And I think, my lord, the point, as I go into the next group of authorities, you will see the point being made where, for example, if you have five authorities that have been, five irregularities have been alleged, and 3 accepted and 2 are rejected, what the court then does in respect of the 3 that have been accepted, individually and separately, then considers whether the irregularity so found has caused substantial injustice. And as the authorities say, that process of consideration is a process whereby the court asks the question, had the irregularity not occurred?
Of course, you have to consider whether it falls in the category and whether it caused injustice, but whether it caused injustice is one and the same, really, as saying whether it's serious, isn't it? It's all a single thing and not two. I can't see the justification for treating those as 2 separate elements.
Well, the justification, my lord, is the fact that from the moment that the section was drafted, the intention of Parliament was that that second element is to provide a layer of protection for the arbitral award. It is a separate consideration.
Well,
in the sense that,
you look at the DAC report,
even if,
which you've taken us to, there's nothing there that says that substantial injustice is a separate test about whether the point's reasonably arguable or not. It's just saying that it's there to make sure that the irregularity has to be a really serious one.
right. And well, if I were to use your verbiage, my lord, in order to determine whether the irregularity so found is a serious one, you have to consider and apply the test, or else you cannot intervene. Even if we weren't to use the word substantial injustice, if we were to use his lordship words, that the irregularity so found must be a serious one, there is a process of determining whether the irregularity is a serious one, and it's a separate process. And this is a process that you see manifested in the authorities, as I've endeavored to demonstrate. So it inevitably is a 2-stage process, and you see it as such in all of the authorities.
Thank you very much.
Yes. And so as I...
Sorry, Mr. Earl, before we move on, in fact, that analysis of our Lord Legate is replicated at page 2025, paragraph 20. And because the judge in that case said the relevant irregularity must be a serious one, in that it has caused or will cause substantial injustice.
Yes.
So the seriousness is given by virtue of it causing or will causing substantial injustice.
Correct. And this is the reason why I endeavored to answer Lord Justice David Legate's question in the manner that it was posed. You know, there's no way for you to determine whether it is serious or sufficiently serious without you going into that second stage of investigation, if I may put it that way.
But I think the point is, first of all, you have to establish an irregularity, and then you have to establish that it's serious by virtue of the injustice that it causes or will cause.
Correct, indeed.
Yeah.
And so that takes me, my lord, into the second point, which is somewhat similar to the first, but what I wanted to do is, after having established that there is this 2-stage investigation, I wanted to take a look at the manner in which the courts carry out the investigation. My learned friend in the appellant's case certainly is that, you know, it is a matter of substance. Indeed it is. We'll leave aside for the moment that each of these 39 cases do indeed use the word substantial injustice, but there is nevertheless an analysis of substance that one would expect to see in the process of determining whether the irregularity is serious, or alternatively, whether substantial injustice has occurred. So there are only 2 or 3 cases that I think really demonstrate the process that the court should be engaged in. The first is at 1895. And if we can turn to page 1905, and this is the authority of Brockton Capital LLP and Atlantic Pacific Capital Inc. So we're going to go to page 1905 and paragraphs 30 and 31. And so we see, it says, thus, whilst the tribunal were entitled to conclude that Brockton had passed up the opportunity of dealing with APC's penalty clause on paragraph 2G1, they were not, with respect, entitled to conclude that Brockton had notice of any penalty clause issue going to paragraph 2G2 and had knowingly passed up an opportunity to deal with that issue. It follows that in deciding that paragraph 2G2 was an unenforceable penalty, the tribunal dealt with an issue of which Brockton had no notice and opportunity to address, and in so doing, the tribunal, in my judgment, acted in breach of section 33(1)(a). Paragraph 31. In my opinion, this irregularity on the part of the tribunal has caused substantial injustice to Brockton. Mr. Smouch submitted that even if Brockton had had notice of paragraph 2G2 and had made submissions thereon, it would have made no difference to the result, since the fact remained that paragraph 2G2 applied to all breaches of paragraph 2E2 and or paragraph 2D warranties, and thus the tribunal would have been bound to reach the same conclusion they did in partial final award. I reject this submission. See, the court is now answering. I reject this submission. It is Brockton's case that paragraph 2G2 ought not to be construed as a penalty because it is a necessary provision, given that TRS is entitled to withdraw from the fund if there is any breach of paragraph 2E2, and or such a submission is plainly arguable and might have persuaded the tribunal to reach a contrary conclusion. In my judgment, such a submission is plainly arguable and might have persuaded the tribunal to reach a contrary decision on the issue, notwithstanding that the opposite conclusion is at least reasonably arguable. So you see in this authority, after having made a determination that there was a serious irregularity under section 68(1)(a), the court then goes into the process of analyzing and applying the text, whether had the arguments been advanced, the arguments that the court has already found ought to have been advanced. Had they been advanced, would there have been a different result? And so that's the type of analysis you would expect to see in the judgment as the court is considering whether or not the irregularity so found is of the requisite serious nature or causes substantial injustice. Similarly, if we go to 1946, and this is the authority of B.V. Sheepsworth, Damon Gorenchem, and Maritime Institute, the Celtic Explorer. If we go to page 1967, and this is another one where the challenge was dismissed, paragraph 45. Even if contrary to the findings I have made, Mr. Vanille QC could demonstrate that the arbitrator had failed to deal with an issue as he suggests, Damon still has to show that this has caused or will cause its substantial injustice. Applying the V-Networks test set out at 33 above, Damon cannot show that the result might have been different, since the arbitrator has held that he accepted and preferred Mr. Gibson's evidence. It is quite clear that even if he were ordered by the court to provide further reasons and to deal with what Mr. Vanille QC contends were issues with which he has not dealt, he would reach the same ultimate conclusion. So again, you see in the judgment the application of the requisite test as to whether or not, having regard to the submissions that the applicant is saying he would have proffered, whether or not the result might be different. And finally, one more, I think, would be demonstrative of the process. If we can go to page 2088. And this is the authority of J.D. Weatherspoon PLC and J. Marr Estates. And we're going to go to page 2095, paragraph 28. Now, as I was endeavoring to respond to his lordship's question, I did make the point that you see in certain of the authorities, when you have a number of serious irregularities alleged, and the court accepts some while not accepting the others, the way that the process ought to work is that in respect of each of those irregularities so found, there should then be a consideration as to whether each of them is sufficiently serious or causes substantial injustice. And that is demonstrative in this case. If we look at paragraph 28, we see where the process starts. And each of these subheadings is a reference to the various different irregularities. So if we go over the page to paragraph 31, you see under the heading cost of fitting, that's an issue. And at the final sentence of that paragraph, you see the court saying, thus it seems to me that JDR have not demonstrated what further evidence they would have introduced on this topic and what, if any, difference such further evidence would have made. The next paragraph, final sentence, that's paragraph 32, final sentence. And the absence of such evidence could not therefore give rise to substantial injustice. Depreciation is yet another issue, and the same process is done as I've described. Each irregularity so found is then separately and independently considered in the context of whether or not it causes substantial injustice, and ultimately the court rejected the contention and dismissed the application. You see this, we say laws, again, each authority where a serious irregularity has been found. You will not find an authority where the court has made a determination that there has been a serious irregularity under one of the paragraphs and has not gone on to consider whether but for the irregularity, the result may have been different, which basically is the substantial injustice.
In these cases you've shown us, Ms. Kroll, the court is dealing with submissions made by counsel.
Lord Leggett, you'll have to pause because Ms. Rawls' connection is broken down.
All right.
We'll see if she can come back in a moment, and if not, we'll adjourn briefly.
Can you hear me?
Ms. Rawls, your connection was interfered with in the last 30 seconds of your speaking, and then Lord Leggett
Yes.
wished to answer a question. So if you'd like to reprise the last thing you were saying, and then Lord Leggett will ask you a question.
I'm obliged. The point that I was making really was in conclusion after having looked at those cases. Simply put, in any instance, and I think in all of the authorities where you find that the court has made a finding of serious irregularity under any of the paragraphs, the court then went on, in respect of each of the irregularities that it found, went on to consider whether in each case the irregularity has been sufficiently serious or has caused substantial injustice. And the way that they've done it is basically literally analyzed what is being suggested the arguments would have been had the party been afforded the right to make those arguments, or if it's a failure to deal with an issue, what would have been the result had the issue been dealt with. And they've applied the text. And so that's the manner in which you would expect to see the court's examination and its treatment of the serious irregularity requirement to look when you look at the judgment.
Thank you. Lord Leggett.
Yes.
In the cases you've just been showing us, Ms. Kroll, the court is addressing in its judgment arguments made by counsel. In this case, was any argument made to Mr. Justice Winder that if the question of termination of the lease was sent back to him, sent back to the arbitrator, there could only be one outcome, and therefore no substantial injustice was caused by the failure of the arbitrator to address the issue, because the arbitrator was bound to come to the same conclusion, even if she had addressed the issue? Was that argument ever made?
Well, that is an excellent question, if I may say so. The argument was not made. First of all, the onus is on the applicant to make those submissions to say that this is the manner in which the award may have changed had the issue been dealt with or had I been given the opportunity to make the submissions. In response, I did make the point to the learned judge that, look, there has been no allegation of substantial injustice, And the response to that submission from a learned friend on the other side was the substantial injustice speaks for itself. Simplicity, nothing further. So to answer the question, those were the arguments, that the substantial injustice speaks for itself. Now, again, as you see, there is an independent treatment of the various irregularities in carrying out the court's duty, if I may put it that way, in complying with the section. And there's no way to know whether that general submission was intended to refer to the paragraph 5 to 8 or only the paragraph 10 or both. But the bottom line is this, and this is going to be my third point. The court did not say, the learned judge did not say whether that submission was accepted or rejected. We don't know whether he accepted. Sorry.
Just one follow-up before Lord Burrows, I know, wants to ask you something, but do you say that if the case is sent back to the arbitrator, it's a foregone conclusion what the outcome of the issue will be?
I do say that, absolutely.
You do?
I do, and when I deal with the issue of whether or not the issues were really where Section 90 was engaged, I do address that point.
Okay.
Yes, and in fact, I do. Yes, my lord.
Yes, the question I had was if Mr. Justice Winder had included a phrase in his judgment as short as, and the substantial injustice speaks for itself, that would have satisfied your objection, would it?
Absolutely. Absolutely. Had he said, Mr. Bethel has asserted that the substantial injustice in this matter speaks for itself, or is of a nature or species where invariably substantial injustice will follow, and I accept that submission, then the requirement would be met. But there's no such phrase at all. And that is the problem, because we don't know whether the learned judge accepted or rejected it.
Well, we do, because he found a serious irregularity, and so he found the test was satisfied.
Well, what he found was that the irregularity asserted fell within one of the paragraphs.
No,
but he did not take the next step.
He found a serious irregularity, which is defined as an irregularity which falls within one of the paragraphs and has caused substantial injustice. That's the definition of it that we were looking at. And that's what he found.
Well, as the authorities demonstrate, implicit in making that second finding is the application of the test. The test being whether or not, had the irregularity not occurred, would the result been different? And he did not apply the test, so he did not make that finding with respect. The finding that he made was a finding of serious irregularity under one of the paragraphs, but he did not take that additional step. Because in the only way he could make, and the authorities, I think, and I don't think that my learned friend and I are in disagreement on this, the only way that he could make the substantial injustice finding is to apply the test. To say that I've considered the evidence, I've considered the submissions, and I accept that the arbitrator's decision, either on the period of damages or on the deductions in the award, would have been different. There's no way of knowing when you read the judgment whether his lordship is of the view that the arbitrator's award would have been different.
Well, I suggest that there is, because one of the points he makes is that the importance of the issue is shown, this is on page 164, by an Australian case.
Right.
And the point of referring to that case is surely to say that, well, there's an authority on the point, so it's a seriously arguable point.
Right.
That's the only reason he could be referring to that case, isn't it?
Well, with respect, my lord, the other reason, and then the reason why we say he's referring to the case, is to establish the irregularity. Now, if he had gone the irregularity within one of the subsections, that is the failure to deal with the issue, because that is within paragraphs 19 to 22, where he's making that point. But as the authority demonstrates,
that isn't the point he's making, because he says the importance of the issue. He's not saying that shows that it was an issue. He's saying the importance of the issue is shown.
Right.
In other words, why it matters, why the issue mattered.
And that is
saying it mattered because there's a case on the face of it directly against the conclusion the arbitrator made.
And I accept that.
It's clear from that, isn't it, that he thought it was a seriously arguable point.
Well, the difficulty there is this. The difficulty there is this. Merely describing an issue as important does not in and of itself give the court the right to intervene, or it does not in and of itself mean that the matter that substantial injustice has been shown. And this is, you see this in the authorities. He had to then take the next step and say, and let's use that example. Let's use the option argument. He then had to say that I'm of the view that had this issue been dealt with as to the enforceability of the option clause, I'm satisfied that the decision of the arbitrator to award damage for 6 years may have been different, or he would say it may not have been different. But there's the mere fact that an issue is important does not mean that the decision may be different, because there are other factors that the court would have to take into play. And I think, well, this may be a convenient time. I was going to make this point subsequently, but to demonstrate that the mere fact that an issue is important does not necessarily mean that the arbitrator may lead to another result, takes into account not just the point itself, it takes into account other issues. So let's think about this for a moment. What is being asserted as it relates to this option is that it's uncertain because the rents have not been determined. But my lord, if you could turn to the lease itself, and the lease is at page 359. And I want to go to page 360. Now, what we see at page 360, this is a continuation of clause 1. So at clause 1A, you see the reference to the nature of the rent, and it is to pay to the lessor such percentage of the annual net gross sales. So the rent conceptually is not a fixed amount. It is a percentage of gross sales. But more significantly, if we can go to Roman numeral 3, same page, where it says percentage rents in respect of restaurant premises shall be calculated as follows. Year 1, year 2, year 3, year 4, year 5. And it sets out what the rents are to be in those respective years. And of course, this is a lease that only has a term of 3 years. But you see that the rents have been established into what could only be the option term, years 4 and 5. So the point is this: the mere fact that the Crown and Melbourne case and the enforceability of the option clause is important does not mean that it might have made a difference. Because in determining the crucial question and applying the test as to whether or not it would have made a difference, you'd have to consider all manner of evidence, including this. Because can you say that the rent is uncertain because the clause itself says to be agreed, when in the lease itself, the rent within the renewal term has in fact been agreed? It's point number one. I don't know that the uncertainty issue is as strong as they are thinking it might be, even though his lordship describes the point as important. But more importantly, remember now, the irregularity is that the arbitrator awarded damages for 6 years, quite independently of the option clause. And if you're looking, for example, at a breach of contract and trespass, what we have here clearly is the parties within their contemplation making provision for the amount of rents well beyond the life of the lease into the renewal term. So isn't it then arguable that it was within their contemplation that their relationship would go beyond just the 3-year term? These would be issues that the learned judge would have to consider before determining whether the option and the enforceability issue would have made a difference to her determination to award damages for 6 years. And so I point you to this, my lord, to make the point that the mere fact that he described it as an important point does not necessarily mean that it would have made a difference, because you would have to take all of these issues into account to determine whether or not it would have made a difference. The arbitrator might well have said, listen, I don't accept that this option is unenforceable or uncertain because I see what the rent is intended to be. Or she may have said, I'm satisfied that I'm still going to award damages for 6 years because I can see where the 6 years was in their contemplation. And I apologize for answering the question in such a long and convoluted way, but the point is this: the mere fact that the learned judge said that it was an important point is not sufficient to satisfy the test that it would have made a difference. I don't know if that makes sense. Shall I continue? So, just mindful of the time. So, my lords, we say that this is the manner in which the judgment was deficient, because the learned judge was required in both instances, that is, in relation to the irregularity that the arbitrator had erred in awarding damages for 6 years, and also as it relates to the deductions that she made. He was required to then take each of those irregularities independently, consider all of the evidence, and opine and make a finding that, having regard to this evidence, either her decision, that is the arbitrator, may have been different, or it might not have been different. And he did not do that. So now, as it relates to the species of irregularity that invariably cause substantial injustice, we do not take objection with the fact that there may well be some manner of irregularity which inherently cause substantial injustice. And my learned friend, on behalf of the appellants, cited a number of authorities. There are 3 of them: the Ascot case, the ASM case, and the Raython case, that make this point. I'm only going to take the board to one of them in support of this.
Again, we need to pause. Ms. Rawle, can you hear me? I can't hear you at the moment. Can you hear me? I'm afraid to say I can't hear you. Can you hear me speaking? No.
Can you hear me?
I can hear you now. Thank you. You've returned to us. You were saying there were 3 cases, and you were only going to take us to one of them.
Yes, and I had identified the cases as being the Ascot case, the ASM case, and the Secretary of State and Raython Systems Limited case. Can you still hear me? I just want to make sure I haven't gone off again.
Well, we can hear you. Thank you.
Okay. The point that I was making before I take you, I'm going to take you to the ASM shipping case. But the point I was going to make is this. I accept, on behalf of the respondents, that there are some manner of serious irregularities, which by their nature may inherently cause substantial injustice. However, if the learned judge were of that view, he should condescend in his judgment to that position. He should say whether it was the first irregularity, the paragraph 5 to 8, that falls into this category, or it's the paragraph 10 that falls into this category, or both of them. There is no such finding, and there is no such identification. Now, when you look at the authorities, you see, bearing in mind now, these authorities are carrying out the same process that the learned judge was. They're hearing challenges under Section 68 of the Act. And if we go to 1859, And this is the ASM case. And I want to go to page 1873, paragraph 34. And I'm going to start at 34 and then go on to 38. So at 34, you see that the court says, though entirely attractive as a general proposition, that is no longer the law as a result of the 1996 Act. The Act does not require the court to speculate what would have been the result if the principles of fairness had been applied, but the Act requires that the court is only to interfere if the court considers, not speculates, that the irregularity of unfairness has caused or will cause substantial injustice. Paragraph 35, it follows that there must be some instances of unfairness on the part of an arbitrator where the court should not intervene. It may be that some instances of unfairness that in fact cause substantial injustice to the applicant will not be the occasion for the court intervening, simply because there is insufficient evidence to lead the court to consider that the irregularity or unfairness has caused or will cause substantial injustice. The policy of the 1996 Act is to make it more difficult to question the decision of arbitrators, not to make challenges easier. So now if we go to page 1880, and it's going to be paragraph G. And this is the paragraph that I want to make.
The last paragraph seems to be contradictory, because the judge is saying that there are some cases of unfairness that cause substantial injustice that won't have caused substantial injustice. It doesn't make sense, does it? Paragraph 35.
Well, it's interesting. The judge is saying that there may be some instances where there's an irregularity and where it causes substantial injustice, and the court may still not interfere. So that just.
I can't understand what he's saying, I'm afraid.
So that's certainly how I read it, and I did find that very interesting. So certainly, if the court is saying that I may well see or find an irregularity where I'm satisfied that it may cause substantial injustice, but the circumstances may be such that I still may not interfere, then certainly you're not going to interfere unless you find a substantial injustice. But in any event, as it relates to the species of substantial injustice, serious irregularity, sorry, where substantial injustice is inherent, if we go to page 1880, paragraph G, actually, there's a paragraph 3 is how it's described. And this is what the court is saying. So here you find the court is making a determination. In my judgment, if the properly informed independent observer concluded that there was a real possibility of bias, then I would regard that as a species of serious irregularity, which has caused substantial injustice to the applicant. I do not accept Mr. Quarles' submission that even if that conclusion was reached, the court must then inquire as to whether substantial injustice has been caused. In my judgment, there can be no more serious or substantial injustice than having a tribunal which was not ex hypothesi, impartial, determine parties' rights. I stop there. So there's a number of things happening in that paragraph. Number one, the court is acknowledging that the serious irregularity alleged in that instance, that is bias, was of a nature where inherently it would cause substantial injustice. But more significantly, the court is accepting that as so, and the court is accepting that in that case, that species of substantial injustice has been satisfied. So you see, the court is actually making a finding. So it's not the issue as to whether or not, and I think it emanated from the dissenting judgment of Justice of Appeal Barnett, whether or not the species exists is really not determinative of the issue in the instant case. The question is, did the Justice of Appeal, did the learned judge accept, number one, that there was such a species? And number two, did he find that the irregularities that he found fell into that category? And did he accept, having so found, that the substantial injustice requirement was thereby met in this case? And I answer all of those questions with no, he did not. He did no such thing. The first time there is a notion of the species of serious irregularity that inherently causes a substantial injustice. It is in the dissenting judgment of Justice of Appeal Barnett. There is nothing in the learned judge's decision where there is any reference to any such species of serious irregularity. Yes, Malone.
Let us suppose that this was the only issue in the case, and you were right, the judge didn't make a finding about substantial injustice, but the Court of Appeal were of the view that this was irregularity which of its nature gave rise to substantial injustice. What should the Court of Appeal do in those circumstances?
Well, the difficulty there, my lord, we would respectfully submit, is that in the discrete scenario of an arbitration, it is not a test for the Court of Appeal to apply. If the Court of Appeal is satisfied that there has been an omission, the only thing the court can do in that instance is to set aside the remittance order. You see, the analysis, when you look at Section 90, it is the court, and in Section 90, court means the Supreme Court. It is the court that must consider this. It is the court that must apply the test. It is the learned judge who must be satisfied. It is the learned judge who must do all of this before he interferes with the award, before he makes the remittance orders. So if he fails to do that, and the Court of Appeal is satisfied that there has been that failure, the Court of Appeal must then set it aside. It's not like a civil appeal where the court sees that there's been an omission, and then the court, under the Court of Appeal Act, has this discretion to then step in and make a determination. Given that this is an arbitration matter, and it's an appeal from a challenge under Section 90, the role of the Court of Appeal, or any appellate court, I would say, is very limited. It is only to review what the learned judge has done in the first instance, because it is only the learned judge who has the discretion under the Act. And so to answer the question, the Court of Appeal cannot then step in and impose its own determination, because it is not vested with the power of the Act. It can only determine whether the discretion was properly exercised or not. Yes, Lord.
If that were right, then the logical consequence would be they should send it back to the judge to deal with the point that he failed to deal with. Is that right?
Well, we did have that. I don't know if his lordship noted from the transcript of the Court of Appeal, we did have that discussion. The difficulty is that the position was never advanced by the applicant. There's no evidence, there are no submissions, there's no contention that the substantial injustice requirement had been met. And so the matter really is done, in my respectful submission. It would be different, entirely different, if the applicant had made the necessary assertions, had made the necessary submissions, and for whatever reason, the learned judge just neglected to deal with it. Then that may well make out a case for sending the matter back. But that did not occur. There's no suggestion from the applicant that, let's say, the first irregularity, the award of damages for 6 years, there was no suggestion by evidence or by submission that the determination of the arbitrator would have been different, and how and why. If it were sent back, then that would create, in my respectful submission, a very dangerous precedent, because what would be happening is that challenges would be sent back to first instance to be done all over again. The only way it could be done is if new evidence and new submissions are advanced. And I certainly do not feel that this would be an instance where that would be permissible.
Well, I thought they were making it perfectly clear. They relied on the Australian case as showing that the option couldn't be exercised. Therefore, it's perfectly clear that they're saying that were it sent back and that case followed, the result would be different, because no damages after 3 years would be recoverable. That's been clear from the start, hasn't it?
As I'd indicated in responding to that question earlier, they're not saying that with respect. They're saying that it's by failing to deal with the issue, that is, whether or not damages should be recoverable in the renewed term, the learned arbitrator ought to have considered this authority and ought to have considered their contention, allegedly put, that the applicant, that therapy was not able to recover damages in the renewal term. But there's no submission, as I've indicated, that the arbitrator's decision would have been different. There's no contention at all from the applicant that had the arbitrator considered that position, considered the case, that the decision to award for 6 years would have been different. So there's nothing in my respectful submission for the learned judge to reconsider if the matter was sent back. And again,
I don't understand that. If they're saying that the lease couldn't have been renewed and the arbitrator should have addressed that point, then it's obvious they're saying that the decision might be different. Unless they will abandon their case, which there's no suggestion they were doing that.
Well, the difficulty with that is that the way in which that particular submission is advanced, you have to demonstrate it would be different by considering all of the issues. And this is the point that I made earlier. It would not simplistically be, here's this case, I'm of the view that it renders the clause uncertain, and so therefore the arbitrator's decision might have been different. That is something that they would have to develop, having regard to all of the evidence, in addition to the fact that Section 1 of the lease actually sets the lease, the rent in the renewal term. And none of that was advanced. And that is possibly in my respect. And of course, as I've indicated, the problem with the notion of sending it back in the context of an arbitration matter is that the intervention ought not to have occurred in the first place. It's not something that you can retroactively rectify. The intervention ought not to have occurred until this issue was fully ventilated by the learned judge. It's not like civil appeal where the Supreme Court is hearing a matter and the Court of Appeal has that jurisdiction. If the intervention ought not to have occurred, the only course in my respectful submission that the appellate court can adopt is to make that finding, that there was no proper basis for the learned judge to have interfered, and that the protection that ought to have been afforded to the arbitration award.
You're breaking up again, Ms. Roll.
Am I here? Can you hear me?
You've come back again. Thank you very much. Could I just deal with one point? This is an appeal. So the appeal to the Court of Appeal would be an appeal under Section 21 of the Court of Appeal Act. Is that right?
Yes.
Yes. And you say that they couldn't make the decision for the Supreme Court. This was something the Supreme Court had to do, but there is no jurisdictional bar on them sending it back to the Supreme Court, is there?
Well, we would say that there is, in the sense that in the specific context of an arbitration and the requirement, if I may put it that way, that the learned judge ought to have carried out this analysis before he intervened. As you see, he's intervened already. He's made remittance orders already. And so if the remittance orders were not properly made, they ought to be set aside, which means that the arbitration award must stand. So there's no context for sending it back.
Thank you.
Yes. So having gone through that, my lord, it might be helpful to now go to the judgment itself of the learned judge to make the point that this analysis has not occurred. And it might be helpful to start with the paragraph 10, challenge, because to a large extent we've had quite a bit of discussion about the paragraphs 5 to 8 challenge. Now, my learned friend had already taken you to the submissions that were put forth by the appellants on the challenge as it relates to the paragraph 10 ground. The paragraph in the submissions about the determination as of the deductions being a wholly impressionistic view that was allegedly adopted by the arbitrator. And you see that the judge deals with that at page 172, going on to page 173, and paragraphs 36 through 38 are the relevant paragraphs. Now, my learned friend had already taken you through paragraphs 35. I won't do that. I will simply take it to 37, but I will say that paragraph 36 is just an express repeat of the submission that was made by the appellants in support of this paragraph 10 ground. Now, let's look at what the learned judge decided in paragraphs 37 and 38. He says, the first time the method of adjusting Mr. Ocasio's global figure so as to arrive at a figure for the Sakara Beach Club was advanced was in the award itself. It does, as argued by the applicant, appear to represent the arbitrator's entirely impressionistic view of adjusting a global figure. Regrettably, the applicants for therapy were not afforded an opportunity, and I think that should be the applicants for the applicants or therapy were not afforded an opportunity to make representations prior to her decision to make adjustments, deductions, and allowances for 1, the removal of the sums attributed to claims which she had disallowed in relation to the varied lease agreement, and 2, the inaccurate recall of the respondent's expert witness, paragraph 38. Having regard to the authorities, therefore, the decision of the arbitrator at paragraph 165 of the award was unfair and contrary to section 44 of the Arbitration Act, and I'm satisfied that this ground ought to prevail. So I stopped there. Unlike what we saw in the authorities that I took the board to at the beginning of my submissions, even though the learned judge accepted the submissions advanced by the appellants as to the existence of this irregularity, the manner in which these deductions were made, the learned judge did not then go on to consider whether, having regard to these submissions, there might have been a difference. For example, what you would expect to see, consistent with what we saw in the other authorities, is something akin to this. This notion of different businesses having different levels of profitability. You would expect that the learned judge would then develop that point and say, had the appellants been afforded the opportunity to make this submission, I'm satisfied that it is a submission that would have led to a different result. I'm satisfied that there may have been a greater deduction. The deduction may have been a half as opposed to a third, or it may have been 20% as opposed to 15%, something. But there's no indication at all that the learned judge was satisfied that these arguments, even if we were to accept that these were the appellant's arguments in support of an assertion of substantial injustice, there's nothing at all to indicate that the learned judge was of the view that these submissions would have yielded a different result as far as the deductions are concerned. Now, yes, the words substantial injustice are not used, but the analysis isn't there either. That test quite simply is the judge being satisfied that there may have been a different result, and it's not there. We don't know what the judge's view is, even though he accepted that this was an irregularity, even though he accepted that submissions ought to have been allowed. We don't know what the judge's view is on what the likely or possible result of those submissions would have been. And that is a failure. That is a failure. And it's akin to the failure that happened with the paragraph 5 to 8 grounds. And so our submission is this, that as it relates to both of the irregularities that form the basis of this appeal, you do not see the exercise that we've seen in all of the authorities that have taken the board to. And indeed, all of the authorities where there has been a finding of serious irregularity, you do not see the application of the accepted tests. You do not see an analysis as to whether or not these arguments, if advanced, may have yielded a different result. And we say that that is something that defeats the judgment. because having not done so, there was no basis for the learned judge to have made the remittance orders. We say that you ought to see analysis, even if it's a paragraph or a line, a sentence, something that shows that the learned judge directed his mind to the requisite tests that, had these issues been dealt with, had the opportunity been given to make the submissions, that the result may have been different. We have no idea what the learned judge's view is on whether or not the result may have been different. And for that reason, we say that the substantial injustice requirement has not been met. And that, we say, in and of itself is dispositive of the appellant's appeal. Now, notwithstanding that submission, we don't stop there. We also contend that in any event, the two irregularities that form the basis of this appeal were not irregularities which engaged Section 90 in any event. And I can now move on to that point, dealing first of all with the paragraph 5 to 8 grounds. Now, in order to make good on that point, it is helpful, if not, I would say mandatory, to go back to the notice of motion. And the notice of motion is at page 68. We're going to go to the paragraph 5 to 8 grounds, which are on page 72. Now, I'm only going to reference paragraphs 5 and 8 because, well, I'll say this. Even though we've conveniently referred to these grounds as the paragraph 5 to 8 grounds, these are separate and distinct grounds. Each of them, well, with the exclusion of ground 6, advancing and invoking a separate paragraph under Section 90, subsection 2. And you see that by looking at them. If you look at paragraph 5, alternatively, the applicants contend that if the tribunal was empowered to determine the issues without the agreement of the parties, which is denied, then it exceeded its powers in awarding general damages for consequential losses, for breach of contract, trespass, and unlawful interference with economic interests for a 6-year period. So you see the substance there being the complaint that the tribunal ought not to have awarded damages for 6 years, but the ground being invoked, the assertion being made, was an excess of power. So that's a Section 90, subsection 2, subsection B averment. So if we go to paragraph 8, you see, in the premises, the applicants say that the award is seriously irregular in that the tribunal, if it had jurisdiction, which is denied, exceeded its powers in awarding damages for 6 years. At best, the tribunal was only empowered to award damages for a period being the remainder of the lease term, that is, from 18th July 2013 to 30th December 2014. The tribunal had no power to award tortious damages for a period prior to the demolition or after the expiration of the lease, term of the lease, sorry. So you see the reference to excess of power twice in ground 8. Now, for the avoidance of doubt, my lord, if we were to look at the submissions that were advanced in support of this notice of motion.
Ms. Rawle, we can't airbrush out grounds 6 and 7. I mean, ground 6 doesn't make it clear which of the headings in Section 90, subsection 2 it's relying on. But ground 7 is quite clearly failing to deal with an issue.
Correct. And those issues are identified. And if I may comment on ground 6. Ground 6, quite rightly, my lord, does not identify one of the paragraphs. But one thing that all of the cases say, as the cases set out the principles that are applicable to a Section 68 challenge, is that the serious irregularity must fall within one of the paragraphs. So if we don't know what paragraph is being invoked by paragraph 6, then ground 6 really is of no use to any of us in my respective submission. Because in order to make the finding of serious irregularity, one of the subparagraphs has to be engaged. And there's no way for any of us to know which paragraph is engaged by ground 6. So really you have grounds 5, 7, and 8 5 and 8 being excess of power, section 92B, and 7 being failure to deal with an issue, section 92D. So now if we go to page 151, which is the submissions that the applicant had advanced before the first instance judge. And again, as it relates to grounds 5 and 8, if you look at paragraph E4.3, do you see that subcaption? Arbitrator exceeded its powers. And paragraph 57 says, not a scintilla of evidence was led during the course of the arbitration, nor at any time did the applicants accept that the lease had been extended as per clause 5T for a further 3 years, 3-year period. No notice had been given by the respondent of an intention to renew the lease prior to the expiration of the lease, and the parties never discussed, much less agreed a rent for the renewal period. Accordingly, the arbitrator exceeded her powers in awarding damages for any period beyond 30th December 2014. Now, the reason why I've taken you to grounds 5 and 8 in the notice of motion and to this submission is because when it comes to the irregularity that was in fact found by the learned judge, that is, that the arbitrator ought not to have awarded damages for 6 years. This irregularity was advanced as an excess of power irregularity, not only in the notice of motion itself. Yes.
Mr. Roll, again, you cannot airbrush out paragraphs 59 and 60 on the following page,
Yes.
where they say the arbitrator never addressed the issue of whether the lease had been renewed, nor did she address the critical issue in the closing submissions that the renewal clause was unenforceable. And then in the next paragraph, the court should set the award aside under sections 2B and D. I mean, with respect, it is unstateable that 2D, subsection 2D wasn't raised in this set of paragraphs, however it may have been headed.
Oh, no, I'm not suggesting at all that paragraph 2D was not engaged. Paragraph 2D was engaged by ground 7 as it relates to those two issues of, 1, failing to deal with the issue of whether the option clause had been exercised, and we've dealt with that earlier. And number 2, failing to deal with the issue as to whether or not the option to renew clause was uncertain, illusory, and unenforceable. Those are the issues.
What point are you making by taking us to these paragraphs?
Here's the point, because remember now, I'm dealing with the issue that the irregularity so found did not in any event engage section 90. And here's why I say this, because as it relates to the arbitrator having awarded damages for 6 years, this challenge was advanced by ground 5 and ground 8 and by paragraph 57 as an excess of powers ground. Now, what is the effect of that? The effect of that, we say, is made quite clear by the Lesotho case, because the principle emanating from that case is, if you are alleging an excess of power, the only question that the court then dealing with the challenge must ask is, did the arbitrator have that power? If that question is answered in the affirmative, then every other complaint is really a complaint about the manner in which the power was exercised, in which case section 90 is not engaged. So, given the fact that the award of damages for 6 years, which was the irregularity that was found, albeit as a section 92D irregularity, it was advanced as an excess of power challenge. And so therefore, applying Lesotho, applying
exclusively as an excess of damages. For you to make the submission, you have to establish that it was advanced exclusively as an excess of damages ground. And my question remains, how can you say that in the light of paragraphs 59 and 60?
I say that, my lords, in light of what was pleaded in paragraph 7. Because it might be helpful to go back to paragraph 7 of the notice of motion. We're guided, as well we must be, by what has been pleaded and advanced by the applicant. And if you go back to paragraph 7, which is on page 672, it says, further, the applicants contend that the tribunal did not deal with the issues put to it, namely, 1, that the term of the lease expired on 30th December 2014 as no notice had been given to exercise the option period for a further 3 years, and 2, that the option clause was uncertain, illusory, and unenforceable, as it required the parties to agree the rents to apply to the renewal term.
Are you saying that's an excess of power challenge?
No, that is a failure to deal with an issue challenge.
Which
But
is
the issues are identified.
Which
The
is
issues-
2D. Which is 2D.
Correct. But my lord, the issues
We
are
see
identified.
2D referred to again in the passage that you've just shown us in paragraphs 57 to 60 of the skeleton argument.
Indeed. But the point I make is this, my lord. The notice of motion and the challenge that is advanced is based, well, the notice of motion crafts the challenge and indicates what the nature of the challenge is. And whereas there are excess of powers challenges advanced in grounds 5 and 8, ground 7 is very specific. And I think what makes ground 7 more specific is certainly the second issue, not based on the authority. The option clause is unenforceable. So 7 is very specific. It's very specific as to what the applicants are saying are the issues that were not dealt with. There are only 2. Namely, whether or not the option was exercised, and 2, whether or not the option clause was unenforceable, illusory, or uncertain. Of the grounds, those are the only issues that were asserted were not dealt with. Yes, my lord.
Was the first option dealt with, issue dealt with by the arbitrator?
We say that inferentially it was, because
Was the second issue dealt with?
the second issue, we say that the second issue was not put to her.
Right.
It was not put to her.
So you accept it wasn't dealt with, but the proposition is that it wasn't an issue for her.
Yes.
Yeah. And whereabouts did the inferential dealing with the first issue, where does that take place?
Well, that takes place in her finding that, number 1, the lease came to an end and therapy was evicted. Sorry, the respondent was evicted prior to the expiration of the term. So
Yes.
if she has made a determination, in fact, I should also add that it is an agreed fact in these proceedings that therapy was evicted prior to the expiration of the first term.
Yeah.
So necessarily, the lease did not come to an end. The first term did not come to an end. So by making the determination that therapy had been evicted prior to the expiration of the first term, she thereby dealt with the issue as to whether or not the term came to an end.
Well, is that correct as a matter of law?
Well, it's correct as a matter of fact.
Well, you can evict someone, but that doesn't stop the lease. The eviction is a repudiatory breach of lease. But if that breach isn't accepted, giving rise to a termination of the lease isn't terminated.
Well, that indeed, my lord, but the arbitrator also went on to find that the lease came to an end. And so that, we say, determines the issue,
Well,
both
that's a different matter.
Yeah, from a factual as well as from a legal basis.
And
so to go back to the point that I was making, when it comes to failure to deal with an issue, Section 7 is very clear. It only identifies 2 issues that the applicant asserted had not been dealt with. And those are the issues. Everything else was an excess of power issue. And so insofar as you are complaining about the award of damages in circumstances where the arbitrator quite rightly had the power to award damages, what you are doing is complaining about the manner in which she exercised that power. And that really is not a circumstance where Section 90 is engaged. And as I've indicated, the Lesotho case makes that point. And so that's one of the reasons why we say, in fact, that is the main reason why we say that it really was not a serious irregularity at all as it relates to that ground. It really was a complaint about the manner in which arbitrator exercised the power that she undoubtedly had. We say the same thing, my lord, about the paragraph 10 ground, and it's something that I think his lordship Justice had questioned my learned friend about. When you complain, well, let me set the context. The deductions that were made by the arbitrator in the course of estimating loss of profits, consequential losses. In so doing, in the course of estimating the loss of profits award, she made deductions. Now, whereas it has been advanced, partially so, that this was a serious irregularity by virtue of the applicant not being afforded the opportunity to make submissions as to what those deductions should be. Again, it is done in the course of her awarding damages. And so, clearly, we say, you're complaining about the manner in which she exercised the power that she no doubt had. And if you're complaining about the manner in which she exercised the power that she no doubt had, again, Section 90 is not engaged. And certainly,
unless she exercises it in a way which is unfair.
Well, that's another one of the reasons why we say, because I'm dealing now with the issue of it not being an irregularity at all. But moving on to that point, was it unfair? We say it was not unfair. And again, we pick up on the question that Lord Justice Legat had put to my learned friend earlier. When it comes to the deductions that were made, they were made as it related to damages sustained as a result of not having the opportunity to operate the Atlantic Seafood Restaurant. It was the contention of the applicant before the arbitrator that there was no variation of the lease, that the Atlantic Seafood Restaurant was not included in the lease, and that therefore no damages ought to be awarded as it relates to the loss of opportunity relative to the Atlantic Seafood Restaurant. That being the case, and I'm fortified in that view, because the Crown and Melbourne case was cited in the written submissions of the applicant for the purpose of demonstrating that the variation of lease that was being alleged in support of those damages was vague. That being the contention of the applicant, that is, that damages ought not be recoverable for the Atlantic Seafood Restaurant. The next step invariably would have been, if counsel were taking the opportunity that was presented for the purpose of making submissions, it is the natural next step that, therefore, any damages that are attributable to the Atlantic Seafood Restaurant ought not be awarded, and that insofar as the Ocasio assessment included damages for the Atlantic Seafood Restaurant, they ought not be recoverable. But that submission was not made. It cannot be said that the opportunity wasn't there. Yes, my lord?
But did your client put forward in the arbitration any case about what damages were attributable to the beach club and what were attributable to the restaurant?
Yes. The suggestion was that within that assessment, approximately 4 million, we had said, was attributable to the Atlantic Seafood Restaurant. And the remainder of the 12 million, that being 8 million, was attributable to the Sakara Beachfront Restaurant.
So you're saying in your case that that 1/3 was attributable to the seafood restaurant, was it?
Well, I don't know if it's a third, but it was 8 million, 4 million. Well, yes, that would make it a third. And so we submitted. Well, of course, we were submitting that it all was recoverable, but the position as it related to Atlantic Seafood was not accepted.
Well, where do we find you putting forward the distribution which was accepted, you say, by the arbitrator? What's the basis for your assertion that that was so? Because my understanding had been that the first time this 1/3 came up was when the arbitrator published her award, and it hadn't been suggested up to then. That time Mr. Flynn was putting it to us. If you say different, then we'd like to see, well, I would anyway, how it was put in the arbitration. so that we can see that actually it was put forward as being a 2/3, 1/3 split, if that's what the arbitrator concluded.
Well,
if he concluded that the seafood shouldn't be taken into account.
Well, what I would say to that is that the notion of deducting a third, I guess formalizing it in that way was done by the arbitrator. But Mr. Ocasio, in the course of his evidence in dealing with the damages, it was an overall award of 12 million, 4 million of which was to be for the Atlantic Seafood Restaurant. And the point is this, though, Malone, as it relates to unfairness, and all of the authorities make it clear, and I don't think that there's any disagreement on what the authorities are saying in this respect. If you have the opportunity to make the submission and you decline to take advantage of the opportunity, then Section 44 from the Bahamian context and Section 33 from the UK context is not engaged. And so if as it was, the position of the applicant was that damages attributable to the Atlantic Seafood ought not be recovered, the next step would then be to move on to submissions as to what he felt the appropriate deduction should be. Now, the fact that that was not done does not create unfairness. That is a classic instance, we would say, of not taking advantage of the opportunity that existed.
But
we also say that
to prove the case, you have to prove how much is referable to the component that you succeed on. It's not for the respondent to make the case for you.
Well,
he can only make a submission if he's got something to address, or if he wants to put forward an alternative.
I have accepted that. The onus certainly in that respect is on the applicant alleging what he is proving what he has alleged. But we do make the point, my lord, that the notion that there was no opportunity to make submissions on the point is dispelled by the very submission that was made not only in writing but orally by counsel for the applicant, for the appellant. Sorry, we say also certainly that insofar as the paragraph 10 ground is premised on the award not being supported by the evidence, and certainly that again is an instance where Section 90 is not engaged. Clearly that is, sorry, my lord. Yes?
Lord Barrows.
Yes.
I didn't want to interrupt you. I just wanted to take you back slightly because I may have misunderstood what you were saying, but I understood in answer to my Lord Legate's question that you mentioned the expert, Mr. Was it Ocasio?
Ocasio.
Yeah. Are you suggesting that he was coming up with a 1/3, 2/3 split? I may have misunderstood what you said.
Yes, I'm suggesting that he came up with, I guess if you were to use a split for the $12 million.
His evidence was that it was a 1/3, 2/3 split.
Essentially, yes, my lord. Essentially.
When you say essentially, I mean,
because it was done, not expressly. It was done in terms of numbers. This is one of the reasons why I said that ultimately, when the arbitrator said I'm going to deduct a third, the concept of a third was done by the arbitrator.
Right.
Yes.
Okay, so it wasn't being suggested in the evidence of the expert as such.
That it would be a third. No.
Thank you.
And we do say, Lord, that in any event, in addition to everything else that I said, that in the process of the discrete discretion that she was exercising, that is assessing an award for loss of profits, making deductions in the course of that assessment, which is an estimate, a discretion that is vested in her. She did not act improperly, and it was not unfair, we say, to the applicant, to the appellants. So we say that in both respects, as it relates to the paragraph 5 to 8 grounds, and as it relates to the paragraph 10 ground, there was no irregularity. Section 90 was not engaged. And that in both respects, we say that any complaint, certainly as it relates to the period for which the damages have been awarded, as being an excess of power complaint ought to have been addressed by way of a Section 91 appeal. That would be the proper way to complain about the manner in which the damages were being assessed. Yes, Muller?
The proposition so far has been that this 1/3 deduction was a novelty. And if you are saying that there is some precursor to it, I'd like to see the page.
Yes. What I can do, Lord, and I do realize that that is an important point.
I was going to raise the same point with you. I think it would be helpful. You haven't that much time now, so I don't want to take you out of your stride. But if after the hearing, you could drop the board a note of the passages in Mr. Ocasio's evidence, which you say sets up the 2/3, 1/3 split.
Indeed, my lord. In fact, I was going to make that recommendation, given that time is drawing nigh. And I'm obliged. I can do that, my lord.
Thank you.
Yes. My lord, there are a few less time-consuming points as it relates to there being no proper finding of irregularity, and I don't need to belabor these points, but I've touched on them somewhat as I've dealt with the other issues. But the other problem is this, and the Court of Appeal made the point. We've looked at the paragraph 5 to 8 grounds, and we've looked at paragraph 7, for example, and we know that as it relates to section 92D, failing to deal with an issue, there are only 2 issues that the appellants asserted the arbitrator had failed to deal with. That is whether or not the lease went to the end of its first term, and 2, whether or not the option clause was enforceable, uncertain, or illusory. Those are the only 2 issues identified in paragraphs 5 to 8 that the appellants had asserted the arbitrator had failed to deal with. When you look at the learned judge's finding, however, his finding of serious irregularity under the paragraph 5 to 8 grounds was solely and exclusively a section 62D finding, that is, failure to deal with an issue. Necessarily, that means that if he's accepting the appellant's case that the arbitrator failed to deal with an issue, he can only be accepting ground 7. But when you look at the substance of the finding that he in fact made, the substance of the finding correlates to grounds 5 and 8, which are that the arbitrator was not empowered to award damages for the 6-year term. So we say, as we wholly adopt the position advanced by the Court of Appeal, which is that, to put it, I guess, in a rather simplistic way, the finding that the learned judge ultimately made was not the case that was advanced in the notice of motion. They do not correlate. And insofar as the board is satisfied that they don't, that also is a basis upon which the finding ought to be set aside. Because you cannot have a challenge under section 90 of the Act where one thing is alleged, one ground is alleged, and the court determining the challenge makes a finding that's inconsistent with what has been alleged. We say that that is improper, and that is another basis why the Court of Appeal was right to set aside the remittance orders. Now, Lord, as I approach my last 10 minutes, I think I can deal with the issue of whether or not the Court of Appeal judgment was final, and what I consider to be my final point together. My final point, my lord, is, I guess, what I would refer to as a Bahamian jurisprudential point. As Mr. Flynn QC has pointed out a number of times, in the course of this appeal, we've only cited UK authorities. In the course of the challenge in the court below, we only cited UK authorities. And there's a reason for that. Because in November 2017, when this challenge was heard, there was no Bahamian judgment on our 2009 Act. So we had no choice, despite extensive research. We could find none because there was none. Now, the result of that has been that this case is the first written judgment from a Bahamian jurisprudential standpoint on a challenge under Section 90. Well, Section 89 and 91 as well, because they were all originally invoked, but certainly under Section 90, and how the Bahamas Supreme Court ought to deal with a challenge under Section 90. Now, in all of the 39 cases that we've cited, and in all of the cases that are cited within those 39 cases, you see the consideration of the substantial injustice requirement. You see the application of the tests. You see the court, quite rightly, giving effect to the ethos and the intention of Parliament in providing protection for an arbitration award. And certainly from a jurisprudential standpoint, we say that the very first authority on the 2009 Act in the Commonwealth of the Bahamas ought to have that same level of clear and unambiguous and express reference to the issues that are engaged by Section 90. Even if the words substantial injustice are not actually used, the process should be there. There's no reason why this authority, as the first authority from a Bahamian jurisprudential standpoint, ought not address the issues in the same manner as the UK authorities have when the provisions are identical. And so from that standpoint, we say, given the fact that it has not been addressed in the manner that it ought to be remained as the Court of Appeal has done, set it aside, and the Court of Appeal judgment should stand. Now, that is somewhat, we would say, related to that being the judgment of the Court of Appeal was final. Now, the application for leave was brought under Section 21 of the Court of Appeal Act, as His Lordship has pointed out. When leave was when leave was granted and the jurisdictional objection was refused, it was refused predominantly on the distinction between Section 90 subsection 5 and Section 91 subsection 5, meaning subsection 90, that is the serious irregularity provision, did not raise the issue that is a judgment for the purposes of an appeal, and it did not raise the requirement of it being a point of public importance. But Section 21 of the Court of Appeal Act was also invoked. And insofar as Section 21, by reference to 1, the revisional jurisdiction of the court, and 2, to this revisional jurisdiction being exercised over any body that is exercising judicial powers. And of course, when you look at the Arbitration Act, an arbitration tribunal is doing virtually almost everything that the Supreme Court does, granting injunctions, awarding damages. Clearly, an arbitration tribunal is also exercising judicial powers. So the question then is Section 21 engaged? And therefore is Section 21(3) engaged, which then means that the Court of Appeal, on the hearing of an appeal under Section 90, is really hearing a second appeal as contemplated by Section 21. And therefore, the judgment in disposing of that appeal is final. Now, it is a point that from a Bahamian jurisprudential standpoint.
I'm sorry to interrupt you late in your submission, but where in the Court of Appeal Act do I see a restriction on the jurisdiction of the board based on the fact that there is a second appeal to the Court of the appeal heard by the Court of Appeal is a second appeal?
Well, there is no jurisdictional impediment. There's a procedural one. Under Section 21, subsection 3, it says that in such circumstance, that is, if Section 21(1) is operative, it means that the Court of Appeal's determination is then final, and the only way that the matter can progress to the board is if the board grants special leave.
Where is this? Sorry, let's look at it. It's at 1784. I mean, it was presented as a matter of jurisdiction, I think, in the courts below, but you're saying it's a procedural matter.
It's a procedural matter. If you go to 23(1) and 3, sorry.
Sorry, which page are we at?
We are at page, sorry, 1785.
Thank you.
So subsection 2 of 23 says that matters heard before, appeals heard before the board, before the Court of Appeal will be final. And then without prejudice under subsection 3 to the Judicial Committee granting special leave.
But it says, save as provided in this section, the decision of the Court of Appeal is final. But what is provided in this section is subsection 1.
Right. And the fact that that is a determination that would encompass a hearing under subsection 21. Because you see, the court, subsection 21, section 21 says that it's a second appeal. It's a further appeal. And this is, I think if you look, the rules also indicate that it's treated as a further appeal, even though when section 90 is engaged, it's not an appeal in the true sense. But section 21 is potentially drafted in a way that it captures not just an appeal, but any revisional exercise over the jurisdiction powers, the judicial powers exercised by other bodies. So I felt as though it particularly, again, given that this is the first authority on the 2009 Act, that this would be an appropriate occasion to address the issue.
What is the procedural mistake that has been made which prevents us from hearing this appeal? And if it's merely a procedural mistake, does not the permission that the Court of Appeal has granted govern or override the procedural mistake?
Well, the difficulty there would be, my lord, with respect, is that if the Court of Appeal did not have the jurisdiction to grant leave to appeal to the Judicial Committee, then it questions whether the leave is valid.
Well, again, you're putting out a procedure into jurisdiction. Where in these provisions is it said that the Court of Appeal didn't have permission to grant leave to appeal?
Well, we say that it's inferred from the finding that the decision is final. If the decision before the Court of Appeal is final, it's final in the sense that there's nothing further for the Court of Appeal, no further jurisdiction for the Court of Appeal to exercise.
But there's a rather, that's 23(2) you're referring to.
Yes.
Yes, but I mean, rather importantly, above those words are the words, save as is provided in this section.
Right. And in that section, that is section 23(1), section 23(1) is referring to civil appeals other than section 21. The ordinary civil appeal that would come as a result of a final judgment or interlocutory judgment from the Supreme Court exercising.
Other than section 21?
Yes.
How do we know that?
Because section 23 is referring to those manners of judgments that one can advance to the Judicial Committee. And those are judgments in civil proceedings where the court is exercising its original jurisdiction, the Supreme Court, meaning exercising its original jurisdiction. The usual appeal, if I may put it that way, that the Court of Appeal may be hearing in the ordinary scheme of things. That's what 23(1) is dealing with.
But if you accept that there is an appeal from the Supreme Court to the Court of Appeal in relation to the Supreme Court's revisional jurisdiction, or its jurisdiction in respect of section 90, then what is it in the words of section 23(1) that excludes the an appeal governed by section 21?
Because section 23(1) is treated as appeals from the Supreme Court, where the Supreme Court is exercising its original jurisdiction in civil matters. And what happens there? Sorry?
where do we see that? You say is treated? Is there authority in the Bahamas which says that there is an appeal to the Supreme Court only, where appeal to the board from the decision of the Supreme, from a decision of the Court of Appeal on in relation to a matter that the Supreme Court has held, exercising its original jurisdiction? Is there any authority confining Section 23 to that interpretation?
Well, I don't know if there's authority that would confine it to the Supreme Court exercising its original jurisdiction, but there are authorities, particularly a whole host of authorities when we're making applications for leave to apply to the Judicial Committee, to appeal to the Judicial Committee, where the reference to civil proceedings is interpreted as civil proceedings in that context, and are not including further appeals contemplated by Section 21.
Well, I certainly I would welcome sight of those authorities. That strangely, I don't think any have been put before us, have they?
You see, subsection 2 of 23, we say supports that conclusion, because clearly subsection 2 is envisioning that the Court of Appeal is making some other decisions that are not contemplated by Section 23(1).
Well, anyway,
save us a provided.
Take up your time, because I'll let you conclude your submissions. But if there are authorities in support of your proposition that Section 23(1) has been interpreted as excluding an appeal in the circumstances that we have here, then I would welcome sight of it.
I'm obliged, Lord. And as I've indicated, it begs the question, if that were not so, what is subsection 2 referring to? What Court of Appeal decision would subsection 2 be referring to? But in any event, my lords, that point, in conjunction with the jurisprudential point from a Bahamian context, brings me to the close of my submissions. And I can summarize them by saying that we do contend, on the basis of all of the authorities that have been cited, that there is this requirement that the court apply the test and establish that there has been a substantial injustice, that it has not been done in the instant case, as is required by the authorities, and that in any event, the 2 irregularities that were found by the learned judge were not irregularities in the true sense. Section 90 was not engaged. And for all of the reasons that I have submitted orally, as well as in my written case, we say that the appeal should be dismissed. Unless there is anything further, those are the submissions of the respondent.
I don't think there are any further questions, Mr. Roll. Thank you very much for your clear submissions. Mr.
I'm obliged.
My lords, I have 9 broad points in reply. First, I would like to make it clear that the appellants do not dispute that there is a requirement of substantial injustice. We made that clear in our written case, and I said it again this morning. The respondent opened its submissions today by taking you through 9 authorities in support of the proposition that there is a requirement of substantial injustice. We don't dispute that. The requirement is in the statute itself. But they don't address the key question in this appeal of how that requirement must be satisfied. We don't even disagree that it may well be good practice in many cases for there to be a separate and express finding of substantial injustice on a serious irregularity challenge. That's especially where one party suggests the point is not reasonably arguable. But that isn't the issue in this appeal. The issue in this appeal is whether there has to be a separate and express inquiry and finding in every case, such that an award must be allowed to stand in its absence, even if the substantial injustice is inevitable or obvious or speaks for itself. The question on the appeal is not, was Justice Winder's judgment a model of best practice? It's whether the failure expressly and separately to address substantial injustice means that a manifestly unjust award of damages should be permitted to stand because the judge failed to say expressly the injustice speaks for itself. Now, picking up on Lord Legate's point and Lord Stevens, the structure of the Act itself is such that the definition of serious irregularity includes a finding of substantial injustice. So a statement by a judge that there has been a serious irregularity, which is what happened in this case at paragraphs 23 and 24 of Justice Winder's judgment, carries with it a finding of substantial injustice. And in our case, in fact, if we just pick up what the judge said, it's at page 165 of the bundle, you'll see exactly how the judge dealt with it. He says at 22, a review of the award doesn't reflect the fact that the arbitrator considered the issue of whether therapy would be entitled to damages during the renewal period. It seems to have proceeded on the basis that therapy was entitled to these damages. Whilst not every argument of counsel demands consideration by the tribunal, this was an issue which turned out to be a central one. And then he says it was first raised in paragraph 70 of the statement of claim and joined by the applicants in their defence. The issue was also traversed in closing submissions. He then sets out the whole of the statute at section 7090 subsection 2a at paragraph 23. And then at 24, he says the applicants were entitled to the consideration of the tribunal on this issue, and insofar as it was not provided, I find there was a serious irregularity, and that part of the award ought to be set aside and remitted pursuant to section 92D. Putting it another way, it is implicit that the irregularity is serious and not a technical one, which it cannot probably be contended wouldn't reasonably have made a difference. And we would actually go further. Even if substantial injustice were entirely separate to serious irregularity, if a judge upholds a serious irregularity challenge under section 90 or under the English section 68, it is at the very least implicit that the judge has found the statutory requirements have been met. Unusually, this is important in this appeal because the core issue is the true construction of the first instance judgment, because it said that Justice Winder didn't say that the injustice spoke for itself, and not because there is in fact no substantial injustice. And what would appear from the submissions today is that it suggested that even if that were the case, the Court of Appeal is powerless to do anything about it, regardless of the underlying merits. Indeed, it appears to be said that even if there was a serious irregularity and substantial injustice, the court should not interfere because this is an arbitration claim. Now, in our submission, that is not right. I should point out, first of all, that an appeal to the Court of Appeal is not an appeal under Section 21 of the Court of Appeal Act. It's a first appeal under Section 90, subsection 5 of the Arbitration Act. And the Court of Appeal itself in this very case accepted that in granting permission to appeal. The key authority on permission to appeal is, in fact, the Court of Appeal decision in this very case. And because my learned friend accepted in her submissions that the appellants put to Justice Winder that the injustice of the irregularity complained of spoke for itself, if the appellate court is satisfied that there is substantial injustice was made out, it follows that Justice Winder's decision was right, and it merely has to allow or dismiss the appeal in question. If it's not satisfied that substantial justice is made out, it can just remit that matter to the first instance judge in the normal way and deal with the submission that was put to it.
Mr. President, Lord Stevens wishes to ask a question.
I'm so sorry, Lord Stevens.
Well, I do apologise. And Mr. Flynn, it's taking you out of your course a little bit. But at page 1785, we have section 23. And I was just wondering whether you needed leave at all, because section 23(1) suggests that you can appeal to Her Majesty in Council if the value is in excess of £4,000. And then it goes on to provide that you can appeal with leave in other types of cases, provided you get leave of the Court of Appeal.
Yes.
I may be reading it incorrectly, and I'd be very grateful for your assistance.
Yes, well, I can tell you, we have basically three reasons why on this issue of permission to appeal. What is said against me is that the Court of Appeal's decision on its own appeal was final because it was a second appeal. That's the case I have to meet. There are two issues with that. The first is that the appellant's Section 90 challenge was not an appeal at all. Justice Winder was exercising his original statutory jurisdiction under the Arbitration Act. So the respondent's own appeal to the Court of Appeal wasn't a second appeal, it was a first appeal. And even if it was a second appeal, there is nothing in the Bahamas Court of Appeal Act which prevents the grant of leave to appeal to the board in such a case. Now, those 2 points are essentially the basis on which the Court of Appeal in this case rejected Therapy's jurisdictional challenge below. Now, I hesitate in those circumstances to agree with you, Lord Stevens, because that wasn't what the Court of Appeal itself said in this case. And I'm afraid, tell you that you're wrong, but equally I cannot say that you're right. It may well be right, but that is not what the Court of Appeal did in this very case. It wasn't one of the grounds that the Court of Appeal gave in relation to this jurisdictional application. They rejected it on those other two grounds. But that may well be right. But it may turn on whether it is truly a final decision or not. I should also say there are two other reasons that I would submit. The first is that the Court of Appeal did in fact give leave to appeal. Now, if that were unnecessary, of course, I gratefully accept that, but they did in fact give leave to appeal, and that appeal, that decision has not been cross-appealed, and we submit they're bound by it. What is said against me in their written case is they say the decision to grant leave is not susceptible to appeal, but that doesn't mean they can resurrect their failed jurisdictional challenge. It just means that the grant of leave by the Court of Appeal was final.
I do apologise again, but what's the difference between a civil action and common law, equity, admiralty, or matrimonial?
Yeah, well, it's a very good question. I'm hesitant simply because sometimes in these jurisdictions, these matters as to whether leave is necessary can turn on, how can I put it, lesser known provisions as to how decisions are treated as a matter of finality. So I'm reluctant to go beyond what the Court of Appeal decided itself, because I would be implicitly suggesting that the Court of Appeal in the Bahamas got their own jurisdiction wrong, which I wouldn't want to do. But I don't think we need to go there, because even if leave were unnecessary, they granted it. It's not cross-appeal. That decision is final. That's the end of the matter. If there were any doubt, sorry,
Mr. Flynn, in many of the jurisdictions with which the board is involved, there can be appeals as of right, but nevertheless, there requires to be formal leave, which is more concerned with technical matters rather than the substantive ground of appeal. So I don't need to detain you on the jurisdictional point. I'd be happy that you proceed with your other points.
I'm grateful, my lord. I know that in the Cayman Islands, particularly, even if leave is not necessary, you're required to ask for leave, just in case, I think, as it were. The final point I was going to make of the 3 points is that even if the Court of Appeal's grant of leave were in some way defective, it would be open to the board to grant leave in the exercise of its discretion if necessary. And having heard the arguments, if you're with me on the merits of appeal, in my submission, it would be appropriate to grant leave in those circumstances. So the short point is, for all of those reasons, this technical point really goes nowhere. If you're with us on the merits of the appeal, you can rely on the decisions given by the Court of Appeal in the Bahamas, the fact that they themselves gave leave and that hasn't been cross-appealed, and if necessary, although I wouldn't suggest it is necessary, but if necessary, the board could themselves give permission. And so really the point goes nowhere in my submission. It's an unnecessary distraction from the main merits of the appeal. That was all I was going to say. We've set out quite a lot more in our written annex, but I'm reluctant to go beyond that in terms of whether leave was necessary. I don't need to go there.
Well, I'm encouraging you to move on to your other points.
I'm grateful. I gather that, my lord. So the second point I was going to raise was that we are not saying it is not possible for a party to submit in the face of a serious irregularity challenge that the case is not reasonably arguable or doesn't otherwise satisfy the substantial injustice test. Again, that's not an issue in this appeal because it wasn't said, apart from the technical point, but on the merits that the claim itself was hopeless. In other words, even if it had been advanced and dealt with by the arbitrator, that it was a case that was that would never succeed. That, as I say, that's not an issue on this appeal. But we do say that it's for the respondent to a serious irregularity challenge to advance a case there is no serious irregularity if they're saying that there's no substantial injustice because the issue is not reasonably arguable. Now, what my learned friend said was that and this is the first time on the merits that I've heard the case advance, it hasn't been advanced in the written case, that if the issue of the enforceability of the option clause went back to the arbitrator, it would be a foregone conclusion, which I take to be a new submission that it fails because it's not reasonably arguable. Now, in my submission, there is no basis for that. The case before the arbitrator and before Justice Winder, the appellant's case, was that the option clause was unenforceable, supported by the Crown Melbourne case. Now, before the arbitrator, that case was advanced. Before Justice Winder, you see it in his judgment. In fact, if we just have a look at that, 164, paragraph 21, you'll see that the judge there identifies the importance of the issue. Paragraph 21 at the bottom, seen in the Supreme Court case of Crown Melbourne. And that's when he goes on to say that that issue wasn't dealt with.
Mr. Flynn, you can give us references if necessary, but we are running short of time, so
I'm sorry.
Press on.
I'm sorry, my lord. I'll rush through it. But what I was going to say is, that so far as we are concerned, this is a point that is not open to the respondents on the appeal. They cannot now say at the 5 minutes to midnight that the point is a hopeless one. That is simply not open to them. They didn't advance that case before the Court of Appeal. It's not taken in the written case. You have no authorities beyond the passing reference to Crown Melbourne. You simply cannot decide that this case is a hopeless one. On the contrary, in my submission, it is plainly arguable, should have been dealt with.
We have that point. You've got another 7 points to make. I encourage you to move on.
I'm going to be very quick, my lord. So third point is, we're not saying on the paragraph 10 point that it is a serious irregularity if a party doesn't take the opportunity on a point in play or in the arena to advance all of its evidence or submissions. Our point on paragraph 10 is that the exercise should not have been undertaken at all as a matter of principle, because the case before the arbitrator was all or nothing, with no alternative case having been advanced by either party and thus not being in play or in the arena. Now, I don't understand anything different being said today. What was said today was that there was a breakdown as between the quantum of the beach club and the Atlantic seafood restaurant, and the expert gave a figure for each. But that is in the context of a global claim. There was no alternative case on liability. In other words, there was no case advanced that if it were only the beach club covered by the lease, the quantum would be X, or if it were only the Atlantic seafood restaurant, the quantum would be X. So it's simply a case of the expert breaking down the quantum figures in the context of the global claim. And that is not sufficient to show that it wasn't advanced on a global basis. Of course, the expert did that, broke it down as between the two, but there was no alternative case as to what the quantum would be if it were only one. That was in the context of the global case. So it's not a question of the arbitrator being able to exercise the discretion. The arbitrator found an alternative case that wasn't advanced. It was global. There was no alternative on the basis it was one but not the other. Fourth, I can do very quickly, the actual reasoning of the arbitrator. The panel asked about that. There is mention in the judgments of the impressionistic approach of the arbitrator. The minority judge does say about the level of damages that they are manifestly unreasonable when their 6.8 million is the consequential damages award, but the pre-estimate of loss is $7,500 per month. We submit that those findings are well made, but it's not a part of our case on the appeal. The serious irregularity is in dealing with an alternative case on a basis not advanced by either party. And in our submission, it doesn't matter if the actual reasoning was good, bad, or indifferent. It shouldn't have been done at all without giving the parties a reasonable opportunity to address the new case, which wasn't before the arbitrator or in play or in the arena. Fifthly, that does emphasise the point made by Lord Leggett this morning. When a party makes an application under a statutory section, it's implicit in the application that they're saying that the requirements of the section are satisfied. So that is, even if the substantial injustice was separate to serious irregularity, if a judge sets out the statute and allows the application, it's implicit in the judgment that he's saying that the statutory requirements are satisfied. It is very wide of the mark in our submission to say that this whole claim turns on the judge's failure to say expressly that the substantial injustice speaks for itself. That also brings into focus the respondent submission that that Justice Winder didn't find that some irregularities necessarily involved substantial injustice. In our submission, it puts the case the wrong way round. There wasn't an onus on the applicants to make that submission. The applicant had to satisfy the requirements of the Act, and it did so, because the regularities it alleged all necessarily cause substantial injustice. But on the facts, they're wrong, and I'll just give the panel the references because I ran out of time earlier and I've run out of time today. But I would ask the panel to read paragraph 1598 in the Court of Appeal, where the Court of Appeal asked Ms. Roll whether the issue, the failure to plead substantial injustice, was raised in the court below, and the answer is given on that page. And it says, no, never, it was never raised. When I responded by way of submission, I made the point. I said, look, you cannot make a finding of serious irregularity because there hasn't been an assertion of substantial injustice. But when my learned friend responded, he said that the injustice speaks for itself, and that was it. So it was, and so it actually was raised. So in fact, that very point was advanced by the appellants before Justice Winder, and the respondent accepted as much in the Court of Appeal below. There's another exchange which is worth looking at, which is at page 1624, at line 19, when counsel, then acting for my clients, set out his understanding of what the position was. And he says something along the lines of, it would have made a difference, there would have been an award of 2 million as opposed to 6.8 million. So on the facts, if you look at the transcript, it's very clear that those were matters that were in fact raised.
You've got 3 minutes now.
Right, I'm coming very quickly. This morning I was going to deal a little bit more with whether this is properly a point of law or a point of procedural irregularity. Was it a Section 91 appeal or a Section 90 appeal? And we say it's absolutely plain, because on proper analysis, this is a procedural irregularity, because on 528, it's about failing to deal with an issue. And on paragraph 10, it's about dealing with an issue that wasn't in play or in the arena. They're not points of law. The fact that the arbitrator goes on and makes findings that are in our submission wrong is not the basis of the appeal. It's the exercise shouldn't have been done in the first place. And so that's why it's serious irregularity rather than point of law. And then my Lord Hodge, just to take up the final bit with your lordship's point on Halliburton, I was simply going to say this, and I can do it very quickly. I took you to ASM Shipping and Norbrook, and they are both, I think your lordship said to me that they're still of assistance to me on this appeal, and I respectfully accept that, because both cases were Section 68 challenges. You can see that from the head note in ASM Shipping. It's a Section 68 case, the same in Norbrook. In Norbrook, it was Section 24 and Section 68, but in both cases, there was a Section 68 challenge. And so all my submissions are maintained, notwithstanding what was common ground in Halliburton. My Lord, I'm sorry I've taken that at quite a pace, but that was all I was going to say. And Lord Hamlin has a question.
I was going to ask, where do I find the order which Mr. Justice Winder made?
That is in tab 7, I think. Oh, is that the granting leave to appeal?
No, the actual order following the Section 90 hearing. I couldn't see it in the bundle.
No, I'm looking at the index, my Lord. If we don't have, if it's not in the bundle, could I ask that we look up the reference if I don't get it straight away? And if it's not in the bundle, perhaps we could provide that to the panel.
Yeah.
Well, Mr. Flynn, thank you very much for your submissions.
Oh, Ms. Wellesley.
I'm told, sorry, my lord, I'm told that it's at the back of his judgment. So that, I suspect, is at the back of tab 5.
I just wanted to clarify whether his lordship is asking for the substantive order on the challenge or the order granting leave.
I'm looking for the substantive order remitting it, effectively.
Oh, that order was never perfected because the terms were not agreed.
Ah, right.
No.
And we just launched into the appeal. I just thought I should assist.
No, then I won't be able to send it to your lordships. But in that case, I would emphasise that in that case, one would then have to look at the terms of the judgment in paragraphs 15.
Yeah. Okay.
Well, I don't think there are any further questions. One point which is left over is identifying the evidence of Mr. Ocasio, which gave a split between Atlantic Seafood and Takara. And I would ask Ms. Roll that you supply us with that within 4 days. And
I'm obliged.
Pardon?
I said I'm obliged, yes.
Obliged. Yes. And Mr. Flynn, if you've got any comments to make on that evidence, if you supply those comments within 7 days.
Yes.
I'd be very grateful. It only remains for the board to thank council for their clear and careful submissions, and also to thank those who have assisted them in preparing the documents for today's appeal. The board will consider the parties' submissions, both oral and written, carefully in deciding what advice that we will humbly tender to Her Majesty. The board will now adjourn. Thank you.